Good evening and welcome. It is my great pleasure and honor today to introduce Professor Upendra Baxi, one of the leading thinkers and legal theorists of our times, who will today deliver the inaugural TLSI distinguished lecture titled Justice Deferred, Transnational Lawyering and the Bhopal Gas Tragedy 30 Years On. So as you all will anticipate this, no introduction does justice to Professor Baxi, but I'll try in my small way to gesture to the extraordinary intellectual versatility, to his activist energies, and to the global influence of Upendra's ideas. So a conventional introduction to Upendra's, I've already slipped into his name of choice. He'd hate to be called Professor Baxi. So a conventional introduction to Upendra's career itself is quite awe-inspiring. So he's Professor Emeritus at Warwick University School of Law. He graduated from Gujarat University, read law at the University of Bombay, and then obtained his LLM and JSD degrees from the University of California at Berkeley. He has been awarded honorary doctorates in law by the National Law School of India, University, Bangalore, and the University of La Trobe in Melbourne. His law teaching career spans several continents, starting in Australia at Sydney Law School, then India, where he was the youngest law professor at the University of Delhi. He was also the Vice Chancellor of Delhi University and the University of South Gujarat in Surat. He was also the Honorary Director for Research at the Indian Law Institute and President of the Indian Society of International Law. He was then Professor of Law at the University of Warwick. Professor Baxi has taught at various other law schools around the world, including in the US, in Canada, and in Europe, and he's very widely published. And he's a leading scholar in several fields all at once: constitutional law, international law, human rights law, sociology of law, legal theory, post-colonial law, and law and globalization. Of the many awards he has received is the 2012 American Law and Society Association's International Award for his contributions to the field of sociology of law. But what is truly extraordinary and inspiring is Professor Baxi's stature as a public intellectual alongside his prolific writing. So I'll give you a few examples, very few examples of this truly inspiring instances of activism on his part. So in 1979, his open letter to the Chief Justice of India, along with colleagues protesting the acquittal of the rapist of a tribal girl, launched countrywide protests and inaugurated the struggles of the Indian women's movement for rape law reform. And I quote from the open letter, and this is about the time when the feminist legal project in the West had barely found expression. So I quote, "But what matters is a search for liberation from the colonial and male-dominated notions of what may constitute the element of consent and the burden of proof for rape, which affect many Mathuras on the Indian countryside." So not only has his writing on social action litigation, where he distinguished the Indian experience from the American one of public interest litigation, been highly influential, Professor Baxi was also engaged in social action litigation from the space of the Indian Law School. So in the early 1980s, Professor Baxi, along with Lotika Sarkar, litigated against the state in the Agra Protective Homes case to protest against the inhumane and degrading living conditions of quote-unquote destitute women who are housed in a state facility, several of whom suffer from mental disability. As Vice Chancellor of South Gujarat University, Professor Baxi facilitated the filing of an MPhil thesis in sociology on the highly exploitative conditions of migrant power loom workers who worked in Surat before the Gujarat High Court. The High Court took suo motu notice of the thesis and then ordered a further study of the sector, for which a team of academics, students, and administrators was formed. And then the court went on to provide legal aid to the migrant workers to fight their case against their employers. Coming more directly to the topic of today's talk, Professor Baxi was Director of Research at the Indian Law Institute in 1989 when the Bhopal settlement order was passed by the Supreme Court. And he spearheaded and hosted the public interest appeals that led to the review order of the Supreme Court. And the 3 books which document the whole Bhopal litigation were written at his instance. He then drafted a potential interim compensation law and advocated for its passage, resulting in the Public Liability Insurance Act of 1991. So consistently speaking truth to power, Professor Baxi is an extraordinary role model for aspiring transnational lawyers who are committed to social justice. But he's not just effortlessly brilliant. He also has a wicked sense of humor, for those of you who know him, and he's an extremely kind and generous mentor. So welcome once again, Professor Baxi. Thank you so much for accepting our invitation. The floor is yours, and he has kindly agreed to speak for about 45 minutes. You have the text of his talk, and then he has kindly agreed to take a couple of questions at the end of his talk. Thank you.
Thank you. You must be all very tired after a long day. Friday you walked, so I could not come with you, and you learned all about how not to write your thesis, and you tomorrow have a happy day. So I'll be very, as far as humanly possible, very brief. Thank you, Prabha, for your nice and encouraging words. I believe in one thing very fervently, and that is unscripted human rights. Human rights are yet to be written. And one of the human rights that is yet to be written is the right to laugh. And that is not there in the universal declaration even. The other human right, which touches me very closely, is the right to have one's obituary, draft obituary, read to one before one passes on. And I hereby approve, Prabha, of much of what you said. You have fulfilled a human right of mine. My friend, in other respects, is a very sexist man, but if you ignore that, and you can't ignore it, his name was Kushwant Singh. And Kushwant Singh was a great historian of the Sikhs in India. He wrote 2-volume history that Princeton published, I think. And he wrote as a good journalist. And Kushwant followed my advice. He rarely took advice, and certainly from a non-sexist person, but he did. And he wrote a book called Obituaries. And the last chapter is obituary of himself by himself. And I recommend you very, very fervently the reading of his own obituary, which has not been excelled, by the way, by anybody after his death last year. So thank you indeed for respecting my human rights. Thank you, Pierre and Prabha, both for being so generous and going several miles to accommodate Prema and myself to come to this workshop. Like everybody else, I learned what transnational law is not all about. Pierre keeps on saying in his writings, which I've yet to cite when I finalize the draft of this lecture address, we do not know what transnational law is, but that's a good thing, because we can begin to think about what it is not, and then something it is. And I'm going to speak about as something which I think transnational law is a struggle against impunity. A struggle by people against impunity. That's my major thing. That's why I regard transnational law as a space of struggle. And that's why I value transnational law. But that is not by any token definition of the term. That's how I look at it. Your scientific, social, and selfless hospitality, we've all benefited from, and we thank you. And I can already say, and I hope you will agree with me, that this workshop is an unqualified success already, although another 2-3 days still remain. I was at King's a while back to discuss something called legal utopias. And there were a number of papers presented at that seminar, and I ventured to distinguish between fiqh, the Sharia, and the kalam in Islamic law. Everybody knows Sharia, but few know fiqh and very few know kalam. And I also spoke about medieval Islamic conceptions of utopia and rationalist and voluntary conceptions of the Sharia. So great is the Euro fatigue with Sharia that I still recall, it's now 8 or 9 years, that I was received with polite and dignified indifference at the seminar. And that is certainly not transnational law. In transnational law, you respect all legal systems. Coming to Bhopal, which is my main theme, it's a sad occasion to speak on the 30th anniversary. And curiously, tomorrow, I think, is the 10th anniversary of the terrorist bombing in London. And I was unofficially debarred by Indian private television when 3 days after 9/11, I condemned, of course, what happened, the crime of New York. But I also added a word about multinational terror that Bhopal was. The terrorists do not have to be individuals, they could be organizations, and most MNCs. In Bhopal, more than 10,000 people were killed when the 47 tons of MIC was unleashed upon them. More than 200,000 people were affected, a large number of them severely injured. A very large number suffered from corneal opacity and number of other defects, including genetic defects. This is now second generation of Bhopal victims. So I said we should also examine corporate terror alongside with the terror of the insurgents, and we should condemn both. After that, not to my surprise, I have not been invited to any television program in India. But I think transnational law should conceptualize terror and non-state actors a little more equitably, if not charitably. And I think we're in the process of doing that. Pierre Paul said, a distinguished lecture, but I divide humankind into two, those that are distinguished and those that are distinguishable. And I speak as the second here, not as the first. There have been a number of catastrophes, which is one of my main submissions in Bhopal. The first one was the release of 47 tons of MIC. The second one was the denial of Judge Keenan of Second Circuit of the United Nations of the forum. He issued a conditional order asking the case to be tried in India and determined as a judge that Union Carbide Corporation will be tried in accordance with Indian law, which gave very little damages for mass disasters. This was a very extraordinary disaster. In any case, Keenan called it the world's largest peacetime industrial disaster. And yet he gave a conditional dismissal, a forum dismissal. And this case was eventually, whatever the Indian courts gave by way of damages, was subject to a garnishee court in New York on the ground whether the foreign judgment satisfies the due process. So Keenan wrote into his judgment not really denying forum conditionally, but he also wrote in his judgment that any decision by the Indian courts will be subject to eventual garnishee court assessment about the due process. But that is the catastrophe we know. That is one. The second and third and fourth, I've counted 4 catastrophes in my paper, are the scandalous settlement orders of the Supreme Court of India in 2009, which granted not merely immunity to Union Carbide from civil and criminal proceedings, which awarded 1/3 of the claim that India made. Named Indian claim was $3 billion for human, social, and environmental damage and suffering. Whereas the settlement orders that were passed settled the case at $470 million. The EU settlement orders further said that carbide shall be immune from all civil and criminal proceedings in India, and the state of India will defend the Union Carbide in all the future proceedings anywhere in the world. This is the judicial settlement order. That's why I cannot but call it a second Bhopal catastrophe, against which we fought, as Prabha told, and in review they struck down the penalty but retained the amount. The third Bhopal catastrophe was the one that occurred in US again. That was when the appeal courts mandated Judge Keenan again, and in America the mass tort situation or mass disaster situation is referred to an expert judge, and Judge Keenan is an expert on Bhopal. Although I invited him to Bhopal, he has not found time to come. I hope someday he will come and see for himself, but he's an expert. In order to be an expert, you don't have to know anything about the people. You have to know everything about what other experts say or do not say, and ability to do a little bit of footnoting, which I've shown in my paper also. So anyway, Judge Keenan ultimately ruled that neither soil nor water was contaminated when 47 tons of MIC, methyl isocyanate, were released. There were other catastrophes like extradition of Warren Anderson. I never had the privilege of my effigy being burned. Prabha, kindly note. But I tried to burn the effigy of Warren Anderson on the first anniversary of the Bhopal catastrophe, and I failed. I could torch the effigy. I didn't know how to do it. Maybe transnational lawyers should not learn how to burn effigies. And that's one lesson I learned very early here, and what transnational lawyers ought not to do. But we tried to extradite him, and we were repulsed by no less a person than, what's his middle name? William Clinton. I forget his middle name. Bill Clinton. Who was playing golf with a black person, a lawyer, Vernon Jordan, who told him not to listen to Justice Department. And Justice Department said this is an extraditable case. So we didn't have extradition of Warren Anderson to send criminal trial. So why do I talk about a catastrophe, multitude of catastrophes that happened so long ago? I talk about them because the Bhopal violated, normally called victims, and I don't use the word victim for a variety of reasons. They form the Bhopal violated, I call them, violated of mass disasters, form a large number of indignation entrepreneurs. and norm entrepreneurs, resolutely addressing the regulatory void about which Pierre writes of transnational law. They continue to suffer and struggle, and they give lasting value to generationally embodied as well as to normative memory. In a sense, they are victims of a perfect crime. I want the quotation from Lyotard, which I want you to inscribe on your heart. No, this way. Thank you. I should not use this. Thank you, Prabha. It's in the nature of victim not to be able to prove that he's using the language of victims, to prove that one has been done a wrong. A plaintiff is someone who has incurred damages and who disposes of the means to prove it. There is no way in which the Bhopal victim violated, or victims, if you have it, could prove that they had suffered the damage, proven in a law court. Because all the research showed that toxicological and epidemiological information about the lethal gas was held only by one corporation in the world, and that is Union Carbide Corporation. And I went as a sister of charity. I went several times to Danbury, Connecticut, as a proxy shareholder. And this time I was from sister of charity, kind enough to give me their proxy. And I asked the chairperson, it is 15 years down the road, why don't you release the toxicological information? There is no legal case pending, but they did not. I need to consider that later, why they did not. But I collected 4,400 abstract, chemical abstract, and I found that MIC exposure was limited to 0.5 on guinea pigs, whereas this was 4 to 6 tons of MIC being stored and released by Union Carbide factory in Bhopal. So judges naturally asked us, how do we extrapolate 4.5 to 4 to 6 tons? Can you tell us, Baxi, how did they suffer from MIC? And of course, I quoted Lyotard to them, but there's no time for the Frenchman. So there is a perfect crime in the air. One becomes a victim if one loses this means to prove, one loses them, etc. And I would like to invite you to turn to the last part, last sentence. The perfect crime does not consist in killing the victim or the witness, but rather in obtaining the silence of the witnesses, the deafness of the judges, and the inconsistency or insanity of the testimony. That is transnational law of mass disasters in practice. Whether it should be otherwise or not is a matter we'll come to in this discussion, I hope. So the violated are very important to me, not merely because I worked with them for the last 30 years, I still continue to work with them, but because they were puzzled by the total impunity claimed by Union Carbide. And in that sense, they were norm makers. And that's what transnational law does, study norm making by agencies other than states. And what did these people set up as a norm? I think they set up people's de lege ferenda versus state lex lata. And that, I think, is the importance of Bhopal violated. I will not talk about the later decisions and the matter. There are plenty of decisions. The last one is in 2014, which is by American Supreme Court and the Alien Torts Act in Cuba. But I will mention that UN Human Rights Council in 2014, as late as last year, at the instance of some Latin American states, resolved to approach the matter of business corporations' liability for mass disasters and human rights all over again. It has acted once in 2005 by United Nations draft norms on business and human rights, which were made mandatory norms. It has acted again after 2005 with Professor Jonathan Ruggie of Harvard, who has given his report, final report on 2014, which the labors began by Professor Ruggie saying the following, and this on my heart. He said, inscribed on my heart, he said, the norms do not deserve the dignity of a third-class funeral. He was clearly in favor of non-mandatory norms, and he worked the right to respect and to protect and to promote human rights. He worked on the soft law declaration. The question that Kibal and other cases and the UN report now raises is whether we should have a mandatory code of human rights responsibility of corporation, or whether we should have a non-mandatory code of human rights of corporation. From the point of view of violator, corporations, particularly multinational corporations, MNCs, constitute two things. They are state-like entities, and they are, secondly, state-transcendent entities. They transcend the local state, and they more and more look like a state, super state. And therefore, impunity, how to deal with the impunity is a problem. Professor Rosalind Higgins, to whom I refer, thought that the entire distinction between subjects and objects of international law was mythical. That we should rather, and this is a fascinating book that she had done a long time ago, I think. The book is called International Law and How We Use It. In that book, she says this is a mythical distinction. Instead of talking about subjects and objects of international law, let us begin to talk about participants in the process of norm making. And impunity of multi-MNC is a norm, not a state of exception, following Benjamin. It's a norm that multinationals that say that only states are bound by human rights, not multinationals. They are private actors, they are non-state actors. And international law only binds the, I'm getting late, and I have so much to say. I must hurry. So, essentially the problem is that of impunity. And before I go to Union Carbide's claiming of impunity, let me say that there are at least 3 or 4 narratives of any mass disaster, and certainly of Bhopal. You can narrate what happened in terms of those who are violated. You can choose to narrate this in terms of those which caused it, MNCs. So there's the MNC-centered narrative, there's a violator-centered narrative, there's a state-centered narrative, there's an international organization, mainly UN-centered narrative, and there might be other narratives. So the way you choose to tell a story will determine whether injustice has occurred. According to MNC narrative, no injustice has occurred. What happened was merely an accident. And accidents will happen in all societies. What is the relationship between accident and the mode of production or the social formation is a very worrying and dense issue. The MNC, in insisting on impunity, insists on one human right, and that is the right, human right to do a moral wrong. And human right to do a moral wrong, on which I am working still, it's a very unresearched area, and I'll be grateful if you also, some of you think it fit to work on this subject. There are only 3 or 4 articles in English, and one of the sterling one is by Jeremy Waldron, and other by Scandinavian ethicist Horstein. When I write an article, it will be the 3rd article on right to moral wrong. But way back in 2007, I had indicated that in capitalism, whether organized or disorganized, there is only one human right, and that is right to do a wrong. You cannot have capitalism without making profit, and you can't have profits without reinvesting them, and you can't reinvest profit without continuously exploiting the worker. And there's nothing ideological about it, that's a fact of life. In capitalism, and if you look at your law of torts, it's all about right to do legal harm. Whole of law of torts. Please think about all the non-fit injuria, contributory negligence, anything about law of civil wrongs. You look, it is the right to do a harm. Free competition, what is it? It's the right to do a wrong, moral wrong. So there is a special mode of production, a relationship with law, which I think the transnational law should study. The impunity is based on the following. On first, free market fundamentalisms, the right to do harm, the freedom of association, property and contract, absolute freedom, the exploitation of labor, and the only social responsibility that MNCs have is to assist the state to develop means of material welfare and gently civilize the states. In other words, community of MNC and private investors claim a total impunity from law, even when they cause knowingly mass disaster. And secondly, colonial knowledges also produce mass disasters. Look at conflict of law. Who developed private international law? These judges and jurists developed the doctrines of what is called private law. In the days of patriarchy, they had said living marriages are okay, are avoidable. domicile of the husband. A wife follows the domicile of the husband. It's only now that there is some stirring in the... So, the ideology there was that of private law. There is nothing public in it. It is transactional law. It is a law in which lex loci determines everything. So that lex loci is the law of where the accident occurs, determines what compensation for harm is owed. Should there be a conditional dismissal, a forum mandate, like in Bhopal, it will be then taken up as a due process matter in the Guarantee Court in the EU or the United States. In other words, decolonizing private international law, knowledges, production of knowledges about private international law, or decolonizing the whole field has to be the object, one of the objects of transnational law. This can be done if you follow the international law. You have to accept it, that lex lata, the division between public and private law. In other words, the plain social fact is that MNCs practice what has been called corporate Neanderthalism. In 21st century, the Union Carbide in 20th century shut off the refrigeration plant knowing fully well that this will cause the gas to escape. But it shut off the refrigeration plant as a matter of economy. It had a similar plant in West Virginia in US where it stored only 10 liters of MIC. And it had a computerized safety system. In Bhopal, it was a rickety safety system. And they stored 47 tons of MIC, which they would not do it. So the transnational lawyers must remember that the state, the word language of host state misleads. Here the state, or third world, which is held hostage by transnational corporations. There is no host state. In home, it is India, which allowed Union Carbide to set up a plant in Bhopal, and you can fault India for that, as we do. But India had no choice. It was to do a green revolution agriculture. It had to produce insecticides, and Carbide, the monopoly of the two of the insecticides, a global monopoly, based on MIC. So generationally, MIC is that the fact that it is hazardous is well known. But the manner of its production and storage and the manner of its refrigeration, all that, it is clear that the corporation caused the catastrophe, hiding behind subsidiary corporation's principle. The Indian company was liable, it was not liable. And I've given the norm-making part of the Bhopal violated in footnotes 28, where they made Government of India assert a principle of absolute multinational enterprise liability for ultra-hazardous industries, which is what Union Carbide is doing. The state-centered narrative talks about victims. The international narrative talks about victims. The UN Code talks about victims, particularly the Ruggie idea. What shall we do? That's the question. Shall we go for a non-mandatory soft law in transnational law, or shall we go in for a mandatory code? As I said, the 1953 UN, 2005 UN draft norms went for mandatory penalties for human rights violation by corporations. I was one of the first to criticize the draft norms on the ground that all human rights were put into the document. I called it the dense intertextuality of the norms. I criticized one-size-fits-all normativity. I criticized the norm for many reasons. But there's a core which was constant. And the core of draft norms was there was legal liability, legal responsibility for those acts from which an MNC has desired benefit from by violating human rights. And therefore, the draft norms, had it been in force, would have applied to Bhopal. On the other hand, Professor Raggi, as I mentioned, favors non-mandatory approach. He favors what is called due diligence by multinational corporations. He favors education of multinational. Just think about it for a moment. Education of Walmart, of Union Carbide, of Dow Chemicals. He favors the idea that they should have some social responsibility. He was the author of Kofi Annan's Global Compact, which we on the activist side in Transnational law said, yes, Global Compact, but with little impact. The Global Compact said to corporations, please take one or two human rights, put them on the website, your website, and every year you say something about it, hopefully nice, but we can't compare you because your corporations are not bound by international law. And now those websites have been abandoned officially by the UN in 2015. So there is something to be said for voluntarism, and we can discuss that. But I now want to come abruptly to a conclusion because I've spoken for long, and I'll skip the founding principles of Raggi text, the idea to respect, protect, and promote human rights. But the idea is, again to repeat, falters when it advocates only an appeal to the good conscience of the corporations. So we should distinguish between two things, and it took me a long time to distinguish it myself, between human rights, the moral idea, as a moral idea. And there's a lot of theorizing and philosophizing on human rights now as a moral idea. And human rights as an idea of practiced lived jurisprudence, like the European Court of Human Rights, the Supreme Courts of various countries and so on, which practice certain human rights as basic. Now, those who follow human rights as a moral idea are parsimonious. There are very few human rights, like Habermas or Rawls. There are three human rights which are Banjul Declaration, on the other hand, African Declaration, everything, UN, everything. So there is a carnivalistic production, normative production of human rights, and there is an abstemious production of human rights. The moral people, those who pursue the idea of human rights as a moral idea, follow few human rights, but they are basic, they are core rights. Those who follow the carnivalistic mode of production are human rights for every constituency, for the indigenous people, for the disabled, for the minorities, for in fact, I've been struggling, I've been fighting very hard. Now I've almost given up. The tourist industry. Tourist industries now want the UN to declare, or has it declared, I don't know, a right to leisure. the Hoteliers Association, the tourist industry, of the airlines have all joined for a declaration on right to leisure, which is a good idea. I want some leisure too, and you want to. But not that kind of leisure, which is corporate sponsored. So human rights, you have to choose between the abstemious model and the carnivalistic mode of production, and which human rights should be binding, and which should be matter of education and further development is a matter of some concern. But besides that, I just narrate 6. I won't elaborate. Oh, how can I forget that? This old man, Mohandas, I've forgotten him, like everybody forgets him in India. I don't use the word Gandhi because that's Sir Richard Attenborough had a film on Gandhi. So Gandhi was a creation of British 2 times over. First, he was a creature of British imperialism, and secondly, he was remembered by the new generation by looking at Richard Attenborough. And Gandhi, there are so many Gandhis in Indian politics that it's difficult to. And I therefore say Mohandas, and I'm not Gandhi, but Mohandas is incomplete without Kasturba, his wife. So I had a reference to him as Kastur Mohan. But they refused, even the Economic and Political Weekly of India, where I write, they refused. The Kastur Mohan, nobody could understand. So we settled on Mohandas. The Mohandas, the Mohandasians. The Mohandas Gandhi long ago said that law is nothing but convenience of the powerful. And the Bhopal violated definitely illustrate that. But I would not go into that. I kept my 6 questions. First of all transnational lawyers must study the last one. What did the plaintiff's brief say? How did they innovate? Thank you very much, Prabha. What did the plaintiff brief say? How did they innovative? How were they innovative in what they said? And why did this fail to persuade the court? There is one thing that you might want to study as to what was innovative in the plaintiff's brief. The plaintiff's victim or violated suing for mass disaster. What do they say? And why were the courts unwilling to assume that? Secondly, does the notion that making profit or recycling profit a non-moral motive? And how do we distinguish moral from non-moral motive? Thirdly, if it's a moral motive, how do we adjust it with other moral motives like human rights? And that's where the mandatory, non-mandatory thing comes in. And if, how do we adjust human rights of the violators with the rights so-called of corporate legal humanity? Should the corporate legal humanity not be considered human? No, that is nobody's case. Everybody's case it should be that they should not claim impunity or immunity from law. And what law? The law of human rights. Again, there's a matter of discussion and debate. Will it matter if we transform the issue of violated into one of justice rather than law? The marvelous story of a British cab driver. It was a man, and a gentleman like me came, well not gentleman, it was a Ruffian like me came and said, take me to the courts of justice. Only one day evening I had to go, and he went all around London and came back. And they posted the man at Heathrow, and the passenger said, but you have taken me round the city of London, it's very enjoyable, whole day, and I'll be returning Heathrow. not taken me to courts of justice. And he texted me and said, I'm sorry, sir, I looked for one, but I only found courts of law. So if we transform this into a problem of justice, would it look different? I strongly urge you to read, if you have not read yet fully, Judith Sklar, S-H-K-L-A-R, Judith Sklar's book called The Faces of Injustice, where she draws a distinction between what policy regards as misfortune, or in Ulrich Beck's words, a side effect of a good deed, double effect, a side effect, he says, or in words of Anthony Giddens, reflexive globalization, where you trust the expert system of technoscience, whichever words you use. How do these words look from the standpoint of justice? Would they look different than if we try? So what is transnational justice as distinct from transnational law? And finally, what I already said, how do we decolonize private international law? What kinds of epistemic insubordination we may practice? Well, thank you for very indulgent patience in listening to all this drivel. And now begins the most important part, the conversation amongst us. I hope I've said something that you totally disagree with.